So firstly, just a very brief introduction. My name's Zoe Adams and I'm a Senior Associate at Michael Lynch Family Lawyers. And the webinar this afternoon will be in respect of spouse maintenance. Just in terms of, I guess, a bit of an outline in relation to what is spouse maintenance, I guess for me, the easiest comparison when I'm trying to, in a snapshot, communicate what is spousal maintenance is I refer to alimony. It seems to be the Americanization of what people commonly think of as opposed to spousal maintenance. So the next slide that we're moving to now is just effectively a little bit more about me. 12 years that I've been practicing in family law, and as I mentioned, I'm a senior associate at the firm. Our firm has been in operation for more than 25 years. We're a boutique firm that specialises in family law. There's currently 10 lawyers, 4 of whom are accredited specialists, and combined we have more than 100 years of professional experience. We are a private law firm, so we only represent clients on that basis, and we provide confidential and professional advice. We offer also a fixed cost initial consultation, so that effectively that enables clients to get some preliminary advice at any stage in their family law matter, whether it's pre-separation or post-separation, and that then allows them to make an informed decision about what steps they need to take moving forward. Okay, so now I'll start the webinar proper, and just going back to mentioning that spousal maintenance is the equivalent of alimony in America. I guess the importance of that is that it's a separate claim, and in addition to what most people think of at the time of separating, which is the division of their financial and property interests. So there's a property settlement, and there may also be a maintenance component, and we do talk about the reason why it's very much a question mark in terms of there may be a spousal maintenance component to parties' property and financial settlement. Okay, so effectively one of the important considerations in spousal maintenance is that it is a discretionary claim, and each case is assessed on its own facts. So there's no formula, and I guess really the importance of that comment in that slide is really in respect of sometimes there being a confusion in relation to spousal maintenance and child support. So child support is in respect of obviously the financial support for children who are dependents, and in that case there is actually a formula that does apply, which effectively takes into account the parties' respective incomes and the percentage of care for the child's age, and then effectively pursuant to the formula and amounts generated. Spousal maintenance is very different. So there's no kind of formula assessment, and it is really one of those areas where if people are considering whether they may either be eligible for spousal maintenance or may be liable for spousal maintenance, they really do need to get some legal advice about what it may be, and to consider as well what the quantum is and what is reasonable in the circumstances. The court has said that that really is a test which does have regard to what were the circumstances during the course of the relationship. So it does vary from case to case as a result, because what is somebody's reasonable expenses could be very different depending upon, you know, their socio-economic circumstances. Okay. The next important communication in respect of spousal maintenance is, of course, the time limit that's applicable. And in marriages, that's 1 year from the date of a divorce order coming into effect. And in respect of de facto relationships, it's 2 years from the date of separation. There's also an important comment at the end there, which is there's no limit to vary a spousal maintenance order. I talk about at the end of today's webinar the ability to effectively try and end spousal maintenance, because that becomes very important. If it is the case that effectively an eligibility arises to spousal maintenance, you want to talk about effectively how long does it apply for, can we bring it to an end, and under what circumstances. So no limit to varying a spousal maintenance order. We will come back to that at the end of the webinar and talk about how you may be able to ensure from both parties' perspectives that there's some certainty moving forward. Okay, as is seemingly generally the case in family law matters, there is also a discretion applicable to spousal maintenance in respect of the time limit period as well. So in addition to the claim itself being discretionary, there's also a discretion as to whether you might be allowed out of time to pursue a spousal maintenance application. So as you can see, the exemptions that apply is if there would be hardship caused to a party or child if leave were not granted, and the party circumstances which is at the end of the time limitation period. So if at the end of the time limitation period, they would have been unable to support him or herself without an income tested pension benefit or allowance, that would be a reason why they might be able to pursue an application out of time. I guess word of the day is discretionary. Just reiterating again, effectively spousal maintenance is discretionary. So even if there is, and there's a hint there as to what's to come, even if there is a need established by one person to obtain spousal maintenance and there's a capacity on the other hand for a person to pay spousal maintenance, maintenance may not be ordered. So we'll talk about some of the situations where that may be applicable. The assessment of need, I really think, has two parts to it. The first is a threshold finding, which is about whether an applicant has a capacity to support themselves through income or capital to a standard of living that is reasonable in all the circumstances due to either having primary care of the children under the age of 18, that party's age or physical or mental incapacity for appropriate gainful employment, or any other adequate reason. So, sorry, I've skipped ahead. That's the next slide, just coming through there. And so really, if you want to use, I guess, what might be the traditional gender roles, what you often see arising in respect of somebody's threshold criteria is, for example, a stay-at-home mother who's got some young children in her care and who may also have reasons why they can't immediately return to the workforce, such as a need to retrain or to I guess, get a foot in the door and work towards effectively improving their employment prospects. What are reasonable needs? So this comes back to effectively a comment I made earlier. So firstly, if you have established that you are in fact eligible due to one of the reasons which was set out in the earlier slide, you then talk about, okay, I'm eligible, one. Step, I guess, 1A or 1B is then how do we actually quantify or calculate what it is that I am entitled to by way of spousal maintenance. So this slide sets out what I would call some of the basic expenses that are calculated in a spousal maintenance application. So rent or mortgage payments, car loan repayments, groceries, petrol and car expenses, insurances such as house, car and health insurance, medical costs including pharmacy expenses. The next slide goes on with additional expenses that might be included, such as landline and mobile telephone, internet access, electricity, gas and water, and household maintenance costs. As I mentioned, there is an assessment based on what was a standard of living during the course of the relationship. So it's not simply about what you would call, you know, the basics, or it being that you've got to live kind of just above the poverty line. It's about, for example, if it was the case, I often talk to clients about this, you know, if it was a case that during the course of the relationship, and again, just to use those traditional gender roles, if it was mum and she was staying at home taking care of the kids, it might have been the case that once a week she was able to go to the nail salon and get her nails done. And it might have been that the husband was able to go and play golf once a week. Effectively, what would be reasonable in those circumstances, and provided that effectively the husband continues to be able to afford both of those expenses, it would be considered reasonable that the wife would be able to continue to get her trip to the nail salon once a week. Other types of expenses that are considered reasonable, particularly in this day and age, are things like, you know, a gym membership and other things that might be considered discretionary, but these days seem very commonplace, such as, you know, your Netflix subscription, your Apple subscription, things of that type. So as I say, it is dependent upon what your circumstances are during the course of the relationship. And I'll touch on this again when we talk about capacity, but also whether that can be afforded upon when there's two separate households, because I think that that's often where the tension lies. That there is, I see a lot of parties where there's seemingly an acceptance that there does need to be some kind of support paid from one person to the other, particularly on a interim basis. But it's about that tension between, well, now that I actually have a rental cost, as well as the cost of the mortgage, as well as my own groceries, as well as my own gas, electricity, phone, etc. There's a real tension about balancing those respective needs that both parties have. So the other important aspect when you are discussing the applicant's need for spousal maintenance is also that there is a continuing obligation to also pursue employment or otherwise mitigate their need for spousal maintenance. So as you can see, one of the references there is to retraining or undertaking studies. So the Family Law Act actually prescribes that as one of the relevant factors in terms of undertaking a course of education or training which effectively would enable them to support themselves. So that's a really common feature where it may be that you're talking about spousal maintenance and talking about, well, how long would this be applicable for? Because really what you're looking for is the person who would be eligible to receive the spousal maintenance also being able to support themselves sometime in the future. Part-time or full-time employment, again, this might be applicable, the differences as to whether part-time or full-time employment might be applicable might be with regard to childcare arrangements. So something we often see is clients who have already done the math and gone, well, look, if I return to work part-time, really what I earn is just going to cover the children's daycare costs. So again, there's that real tension about what is appropriate, because if it's only part-time as the appropriate first step, is that actually commercially sensible really for the family? Okay, so that's, as I say, parts really 1 and B, which is basically, have we got an eligibility criteria? If so, let's do, it's almost like a weekly budget, and let's calculate all of what the reasonable expenses are. And that's step 1 of the process. So now we're moving to step 2 of the process in determining a spousal maintenance claim. And that is the respondent's capacity to meet some or all of the maintenance sought. So effectively, it's about assessing the surplus after paying their necessary commitments. We do put this into play in a little bit further down the webinar, where we actually provide a case example. So bear with me, it's sometimes a little bit more, academic at this point, whereas when you see it in practice, it all kind of comes together. But effectively, you are looking at, for example, as I mentioned, that idea of there is a tension between what are your own reasonable expenses before you're required to meet the expenses of another person. And going back to that comment I made earlier about the nail salon and the golf game, again, if it's the case that you say, oh, well, I can continue to pay my golf game, but she can't afford to go to the nail salon, the court goes, oh, well, no, that's not really fair. That's where they often exercise their discretion and say, well, it's kind of same. So if you can afford to still go to the golf game, she can afford to go to the nail salon. If you're saying I can't afford the nail salon, you're going to give up your golf game too. So as I say, it's that kind of discretionary area that you often see the court exercising some kind of element of what's reasonable, but also what's fair. It's also important, I guess, to talk about what's not income. Oh, sorry, I might have skipped us. No, it's all right. We'll get to the next slide. What is not income is basically certain pensions and government benefits and child support payments. I guess really when we're talking about pensions in this category, we are talking about certain pensions that are paid by the government, which is distinct from somebody's eligibility potentially to receive another type of pension, whether that's due to their previous employment or some other kind of insurance policy. What is income? So we've got there obviously some of the standard things that people can kind of readily identify as what does represent income. So salary and bonuses, rental income, employment benefits, share dividends, and foreign income. In addition to what the court may consider in respect of the respondent's income, they can have regard to property, financial resources, and the respondent's earning capacity. Again, I give a bit of a case example in relation to where that may become applicable, particularly in respect of, for example, somebody who's on paper doesn't appear to have a very high income at all, but realistically they're able to draw a significant amount of resources to meet discretionary expenses or other expenses on their behalf, and the court really says, well, you know, we're going to also include that when we have regard to what capacity you might have to meet the other person's spousal maintenance claim. Then we talk about, you know, what is the appropriate type of order, or the different types of spousal orders that are made. So in daily practice, we most often see an interim spousal maintenance order made. So really that is about this idea of, I need some immediate support pending the property settlement. And it's often the case that as part of a property settlement, there might be a short continuation of a periodic payment continuing, but more commonly we see a lump sum payment being made at the time of the property settlement. Again, I will go through in today's webinar some of those kind of examples. How long does a spousal maintenance order last? This is the million-dollar question, you know. This is something that is subject, not only is the quantum subject to discretion, but so is the duration of the order. Obviously, it's for as long as the order states, but generally speaking, it is about setting a certain point in time as to when somebody will be able to support themselves. The default situations are also described in this slide. So effectively, if there was an order that was applicable for, say, 5 years, but in the intervening 5 years, there was either remarriage of the recipient, death of the payer or recipient, or a significant change of financial circumstances for either party, that might be reason for a spousal maintenance order to be brought to an end. But generally speaking, as I mentioned, you would normally have an order which is kind of tied to when you might think somebody is in a position to support themselves. That might be either a period of retraining, or it might even be that it's applicable to somebody's ongoing care of a child. So for example, if a child is under school age and it's anticipated that somebody's going to be able to return to full-time work once once the youngest child is attending school, that might be an appropriate time for a spousal maintenance order to be brought to an end. Okay, so what we have now is the case example that we are going to run through today in relation to tying together some of that theory that we've just talked about in respect of spousal maintenance and how it might apply in a particular relationship scenario. So this is kind of, you know, just the general background information that you often take into account when you're first assessing the eligibility of a spousal maintenance application. So Dre and Nicole were married and they separated after a 12-year relationship. They now have 3 children who live with Nicole. They're aged 8, 6 and 3. The 2 oldest children are attending formal schooling, but the youngest child does not attend daycare and is cared for full-time by Nicole. Dre is employed as a music producer, which requires him to routinely travel up and down the West Coast. As a result of effectively the type of employment that Dre has, he spends time with the children when he can. Sounds like Dre and Nicole have a amicable co-parenting relationship. He can give Nicole a bit of notice, and effectively she ensures that the children spend time with him, usually in 1 to 2 day blocks, but always on different days. Again, the relevance of some of this information becomes particularly applicable when you're assessing Nicole's ability to effectively return to employment. You know, if it's the case that there's, I guess, a kind of almost changing of the children's arrangements on a regular basis, very difficult to secure employment that would be capable of being working around those parenting arrangements for the children. And of course, the court wanting to prioritise the children continuing to have a relationship with both parents. Likewise, in terms of Nicole's role as a parent, that would be something the court would take into account in terms of her wanting to retain that role, no doubt, and particularly as it relates to the 3-year-old. So a lot of people, again, one of the real tensions that I talk about, so one is about, you know, how do we actually meet the running costs of 2 households? The other is this idea of, as an intact couple, we agreed that effectively the time that Nicole was going to return to work wasn't until our youngest was effectively of school age. But can that now apply? Our relationship is broken down. Is that something that's still affordable, basically? Or is there now going to be a requirement on Nicole to actually pursue some greater level of employment, or at least be retraining to re-enter the workforce? Okay, so Nicole previously worked as a lawyer, but she's not worked for 8 years. She receives family tax benefits of $250 a week, and she also receives child support payments from Dre of $500 per week. She lives in the family home with the children, and he's paying the mortgage of $500 per week. This is a bit of a test case. I guess some of the things you would be thinking about as you're looking at this slide is thinking about Nicole's receipt of family tax benefits and whether that would be taken into account. As I mentioned earlier, there's effectively a position within the legislation which states income tested pensions are not taken into account in spousal maintenance. Now, the reason for that is effectively formed as a result of public policy. It's the idea that effectively, if the husband is able to support his wife, he should, and the public purse should not be. So basically, first thing we're seeing in terms of a bit of a red flag in this case is Nicole's receiving family tax benefits of $250. Effectively, for spousal maintenance purposes, that would not be taken into account. That would be disregarded. What's important to also know is that there would also then likely be a change if a spousal maintenance order was made in Nicole's behalf, that she likely would then become ineligible for that family tax benefit, again, because of it being that public policy decision. It wouldn't be the case that she effectively gets to double up both spousal maintenance and family tax benefits. So she would have an obligation to report the spousal maintenance that she's receiving from Dre. Child support payments from Dre. Going back to, again, an earlier comment that was made, child support is effectively not income. So that's not something that she's effectively supposed to use to support herself. It's supposed to be for the children. She lives in the family home with children. Dre is paying the mortgage of $500 per week. So again, at this point, you would be thinking about what is that $500 per week? Is that in fact spousal maintenance? Is that part of Nicole's reasonable weekly expenses? Nicole's come into our office. Let's pretend Nicole's our client. She's been very helpful in terms of she's already done a weekly budget and she's calculated her expenses at $2,000 per week. $1,000 for the children and $1,000 for her own expenses. Polling question, don't worry, nobody's going to be put on the spot here. What is Nicole's need for spousal maintenance? It's a little bit of a, again, a question that could have two answers. Firstly, let's talk about the children's expenses. The children's expenses are $1,000 per week and she's getting $500 per week from child support. Today's webinar is not about child support, but effectively, if she doesn't consider the child support amount to be appropriate, that's something she takes up with the child support agency. She can't effectively tag on the children's additional expenses to her own and claim that as spousal maintenance. So at the very outset, you'd be looking at, okay, Nicole's need for spousal maintenance is the $1,000, which is applicable to her own expenses. We're then looking at, I guess from my perspective, I would be starting to unpack that question or that comment earlier about Dre paying the mortgage. So if he's paying the mortgage on her behalf, when she says her expenses are $1,000 per week, does she mean it's $1,000 plus I need Dre to continue to pay the mortgage? Or is she saying of my $1,000 expenses, $500 is the mortgage which he's already paying? So in my view, there's two correct answers to this question. It could either be that her need for spousal maintenance is $1,000 plus the mortgage, or it could be that it's $1,000 including the mortgage. Okay, move on to the next slide. So we've done steps 1A and B for Nicole. She's established that she's eligible for spousal maintenance by reason of having both the care of the children and also being out of the workforce for 8 years. She's going to need to retrain, do something. She's got a little one who's 3 years old. That role is going to be respected as a parent. So now we say, okay, she's eligible. We've quantified what the need is. Now we need to assess what is Dre's capacity to pay. Dre ceases paying the mortgage at $500 per week. What is Nicole's need for spousal maintenance now? So as I said, this goes back to that there's two correct answers. Effectively, if it was the case that her need was $1,000 plus the mortgage, obviously her maintenance now is, her need now is $1,500. If it was the case that it was inclusive, obviously it is now the case that she needs $1,000, not $500 plus the mortgage. Oh, I guess, you know, it's the same outcome, but again, it's just important to be mindful of what are the expenses that might already be benefiting Nicole that is, I guess, what you could call quasi-spousal maintenance. So something that people often don't take into account, for example, is that there might be a continued payment of certain expenses on their behalf, and they've kind of included that in their weekly budget. So, for example, common ones that I see that are kind of forgotten about are things like car registration and insurance, health insurance, and household and contents insurance. Again, because they're often set up in a direct debit account and they're getting paid for, and people don't effectively properly calculate what their need is because they're kind of double dipping. They're putting it both in as an expense, but they're not taking into account that it's already being met on their behalf. Okay, then we're talking about what is Dre's capacity to pay. He's got a salary of $5,000 net per week. His personal expenses are $3,100 per week, and he's paying child support to Nicole of $500 per week. What is his capacity to pay? So effectively, subject to the court exercising some discretion and saying that $3,100 might be something that's kind of considered a bit excessive for his own personal expenses. But if the court found that to be reasonable, effectively we're looking at his capacity to pay spousal maintenance to Nicole is $1,400. That is, it's $5,000 less $3,600 that he's already paying for both himself and for child support for his children. Just at this point, I guess there's always that important factor, which is what is Nicole doing to have to mitigate her circumstances? So if it was the case, I mean, in this situation, Nicole's a lawyer, but for whatever reason, we often see it being nurses or teachers, and there's that requirement for a retraining period for their qualifications to become revalid, so to speak. So sometimes that's what's going to be required. Sometimes what else can be required in regards to a profession is, again, that idea of you're working from the bottom again. So people often think about, oh, well, she used to earn $80,000 or $90,000 as, you know, a HR manager or something of that description. If she's been out of the workforce for 8 years, there needs to be, I guess, some reality testing there in respect of she's going to be likely getting an entry-level position. It's not going to be the case that she'd be able to walk straight back into a job at that same level. So there does need to be some mitigation. So often what you will see is that there needs to be a continuation of, for example, provision by one party to the other of efforts that they're making by way of and basically a job hunt. So, you know, these are all the jobs I've applied for, or this is the training or course that I've enrolled in to participate so that I can effectively upskill or up-qualify for when I do return to the workforce. So again, the court won't look favourably upon people who are not prepared to actually mitigate their need for spousal maintenance. And in fact, it's not one of the cases I've included in the slides today, but there was a case that actually talked about, you know, you don't get to rest on your laurels, so to speak, if it's the case that you were fortunate enough to be in a situation where you were not required to work because somebody had a particular level of wealth. It's not simply a matter of simply assessing, well, this was the standard of living I had during the course of the relationship. As I said, the court assesses what's reasonable having regard to what was a standard during the course of the relationship. So I think that hopefully makes it a little bit clearer in terms of, and you'll see, sorry, it's brought together in this final slide here. What's the likely spousal maintenance order that will be effectively made? The expenses for the house and her is, sorry, I should read it exactly as it's written on the slide. Effectively, her expenses are $1,000. The expenses for her and the children where they reside is $600. So the entire need is $1,600, but his excess income is $1,400. What spousal maintenance order will the court make? Effectively, in this situation, we're going to work on the very basic assumption that effectively it is going to be $1,400 per week. So even though Nicole has a greater need, the court's final determination is with respect to what is the respondent's capacity. So it's kind of that old saying, you know, you can't get blood out of a stone. If the money's not there, you're not going to be required to pay it. So it's often the case that there is a real need by one person to be financially supported, but on the other side of the fence, sometimes it's really unfortunate there isn't a means to actually meet that need in the full quantum that is sought by the other party. What I can say is that there is a bit of an exception to this, and we'll talk about it in the case examples that are coming up in the next couple of slides, and that is sometimes the court can determine that if in fact the reasonable need has been determined, they can in fact make an order that it can be met, for example, by liquidation of property or by using some kind of financial resource to meet that reasonable need. So this is where you start to get, I guess, a bit crafty in terms of how the orders might be prepared if you were, for example, acting on Nicole's behalf and trying to fashion an appropriate set of orders for what it is that she requires by way of financial support pending settlement. So as I mentioned earlier, it might be that what you suggest is an appropriate spousal maintenance order might be encompassing really two components. One is what is the periodic amount that Dre is going to pay into Nicole's bank account, and there might be another component, which is he will also continue to meet certain expenses on her behalf, such as private health insurance, gym membership, something of that description, you know, so that basically, as much as is possible, Nicole's going to be able to support herself pending either retraining and supporting herself, or, as I mentioned, having her final property settlement. Okay, so that's as I said, that's a really simple case scenario, but I've got to say it's actually quite consistent with the type of cases we deal with. And as I mentioned, in this case, although there hasn't been any comment made, I do think that the court may be somewhat critical of Dre saying his expenses are $3,100 per week, and it may be that the court does find that he does in fact have a capacity to meet the $1,600 that's being sought by Nicole. And as I said, if they can't find that on the paper, so to speak, they might otherwise require him to liquidate some kind of property and pay that to her as a means of ensuring that her reasonable needs are being met. Okay, so some principles that are established by cases in respect of maintenance. This is just, I think everyone likes a bit of, again, examples in practice in relation to what has the court done in earlier cases. So Bevan and Bevan, it's a really highly quoted or referenced case. And the reason for that is because we often, again, see this type of situation arise, which is it might be the case that again, whether it's on an interim or a final basis, that effectively the wife has some funds in her bank account or which she has access to, or she has some property of value, and effectively there might be a suggestion, well, she can go off and sell that, or she can go off and use that money. And basically this court case is about the idea that effectively if there is a capital sum, it shouldn't have to be depleted by the applicant if the other respondent is in a position to pay spousal maintenance. So again, it's a discretionary test. It may be that in another situation, a applicant may be required to actually deplete a capital sum because effectively the other person's income may not be able to effectively meet the entire quantum of the spousal maintenance that's being sought. But in this case, there had been a property settlement and the wife had received really only a meagre capital sum. And I guess the importance in this case is understanding that effectively, say the net property pool was $300,000 and she was receiving a certain portion of that. It was the case that like the husband's earning capacity was like $300,000 a year. So the court was basically saying, well, she shouldn't have to deplete that, you know, that what she's received out of that really modest property pool to meet her reasonable living expenses. If he's earning $300,000 a year, he's got a capacity to continue to meet her expenses, at least until she's able to support herself. This next case, it's quite an old case, but I think, you know, it's still very relevant today. I'm loath to pronounce it, it's probably not correct. Taguchi is what I'm going to call it. And effectively, in that case, the wife was an artiste and she thought it was kind of a bit below her, this idea that she should be required to go and find regular employment. And basically, the court made a finding that she was capable of finding employment if she chose to do so. And effectively, as a result of her election to not seek regular employment, the court said you're not entitled to spousal maintenance. So again, just reiterating that importance, I guess, really, if you're acting for a wife, and again, coming back to that, you know, I've been able to have a certain lifestyle. I want to be able to continue to do that. Why should I be required to go out and get employment? This case often comes up. Well, you know, there's an obligation. It's clearly established. It's been a long-standing case now, effectively saying you do have an obligation to go out and try and meet your own needs. So then on the other side of the coin, we've got a couple of cases here, which is in respect of the respondent to an application for spousal maintenance and what is their capacity to pay. Eli and Dot, again, excuse my pronunciation, I might not have got that correct, but effectively, this was an interesting case because, again, a common scenario which we see in family law cases is somebody's a bit tetchy about actually disclosing their financial circumstances. So this was a case where the husband hadn't made full disclosure in respect of his financial circumstances. But one thing the court did know was that over a course of about 12 months, he'd paid his lawyers $180,000 to oppose the wife's application for spousal maintenance. So effectively, the court was of the view that if he's got a capacity to pay his lawyers $180,000 per year, that's his capacity to actually pay spousal maintenance for the wife moving forward. So I think that was really kind of a bit of a, I don't know what you call it, but a bit of a punch in the guts, kind of a bit of a wake-up call, I guess, for people who do try and take that approach, which is, you know, if I kind of duck and weave and hide my financial circumstances, the court won't be able to make a finding against me. There's ways that the court can be a bit creative about finding that people do have capacity. And in that case, the court also had regard to how he was paying his legal fees. So it wasn't the case that, you know, the $180,000 had been a capital sum that he had depleted. It was the case that he actually had received that from companies and trusts and so on. So very easily able to establish to the court, well, that's effectively what you would consider a financial resource that he has available to him. The next case is Brewer and Brewer, and I think that this is also a good case in point because, again, people who are a bit loath to meet a spousal maintenance claim, and I appreciate sometimes where the frustration comes from, but, you know, I'm not going to like continue doing what I'm doing and, you know, working 12-hour days effectively to maintain a certain lifestyle for the other party. So I can certainly understand that position. This is a bit different, but it's important to bear in mind, I think, when, again, you're advising the respondent. People go, oh, well, I'm just going to effectively resign. My earning and my ability to meet the spousal maintenance application will be gone. Well, not quite. The court effectively in this situation didn't find that, you know, the husband, again, didn't just quit his job. He tried to effectively get some medical evidence together to suggest that he was no longer capable of carrying out his employment. Court didn't accept that and basically assessed his ability to pay maintenance based on his earning capacity. I mentioned earlier, and it's worth repeating here as well, although this is not about child support, the child support agency can definitely take a similar approach in respect of child support as well. So people, again, often try and say, that's a ridiculous amount of child support, I'm not going to be paying that level, I'm going to quit my job. And basically the child support agency on application can actually consider whether it was reasonable for them to quit their job or not. So coming back full circle to something that I said at the very beginning of the webinar. So that's the end of the case example, sorry. But what I'm coming back full circle to is this idea of, particularly as lawyers, you know, we're always looking for obviously ways to kind of bring certainty to parties' lives and also ensure that we're protecting our clients' interests. So spousal maintenance, as you've probably gathered, you know, can have an order that's in place that effectively compels somebody to provide a level of financial support. As I mentioned earlier, the difficulty with once an order is made is that you are able to vary it at any point in time in the future, and there is no time limitation period in regards to that order, that spousal maintenance order. I mean a final order, of course. I'm not talking about an interim order. An interim order would be brought to an end at the termination of the court proceedings. But it could be the case that a court made a final order for spousal maintenance, and it was, say, for a duration of, using my example earlier about retraining. And say, for example, the person needed to retrain for a period of 2 years because they're doing part-time study, looking after the children. The children are then re-entering school, so 2 years, and it's supposed to be brought to an end at that period of time. The difficulty arises if the wife's effectively not able to complete her study within that time. Say for no fault of her own, she's not able to complete it in time, or she's not successful in completing it, or there's some particular issue with the health of the children, it would be the case that effectively she could seek to vary that order. So that doesn't create certainty for anyone, and it's a highly risky area to be in. So what we often talk about with clients is effectively extinguishing spousal maintenance claims, and there's only one means by which you can successfully do this, which is by entry into a financial agreement. That's really important because, as I mentioned, you will see that often people try and enter into a spousal maintenance order thinking, okay, once it's brought to an end, once it's complied with, that's the end of it. No, you can even vary a lump sum spousal maintenance order. So effectively, it's really important that if you do think that you have a client who potentially is either eligible for spousal maintenance or alternatively is liable for spousal maintenance, that you consider the need for specialised family advice, and particularly whether they need to be entering into a financial agreement. Financial agreements in respect of maintenance, couple of really important points, and although it's second in the slide, I'm actually going to talk about the second point first, which is section 90F capital 1A of the Family Law Act. This is effectively the one ground upon which you can't enter into a financial agreement regarding spousal maintenance, or not necessarily you can't, but effectively the financial agreement doesn't work. And I guess that's really important because I've just flagged, hey, you know, enter into a financial agreement to make sure spousal maintenance is brought to an end. But you need to be aware that there's this one situation where you will not be able to successfully enter into a financial agreement to bring spousal maintenance claims to an end. And that's where effectively the person eligible for the spousal maintenance is unable to support him or herself without an income-tested pension allowance or benefit. So again, public policy decision by the legislation, at the time the legislation was prepared, I should say. Effectively, it shouldn't be that the public purse is paying for somebody's reasonable needs if the other person has a capacity to meet them, particularly in circumstances where they would otherwise be eligible for a pension allowance or benefit. The other important thing about getting specialised family advice is that earlier comment, which is, or statement which is in the legislation, taking into account the terms and effect of the agreement. So often if you have a financial agreement, you need to make sure it does in fact make adequate provision for somebody's spousal maintenance, because if it's the case that after the terms implemented, the recipient's still eligible for an income-tested pension allowance or benefit, then it's not going to work. So sometimes people's spousal maintenance is sufficient that they no longer eligible for a pension allowance or benefit, and therefore it does work. So that's why I mentioned you really need to get some specialised advice about that, because some people effectively try and say, oh, well, you know, we're going to draft a financial agreement in a certain manner, and although the theory is right, in practice they just haven't done it correctly to make it work. Which is part of what the above section talks about, section 90E. Effectively, a financial agreement is void unless it specifies for who the maintenance provides and the amount provided for, or the value of property attributable to maintenance of the party. So again, it might be that the agreement stipulates there's going to be a periodic amount, you know, it's $300 per week for a period of, you know, 52 weeks or something along those lines. Alternatively, it might be in lieu of giving the other party spousal maintenance, in fact, I'm giving them $50,000, $60,000, something like that. So it's effectively, it's just important to determine what is the spousal maintenance amount that's being provided in that financial agreement. I think that's it. We've been brought to an end. So in addition, I'm just going to finish off one further comment in relation to a financial agreement regarding maintenance, and that is that effectively we are looking at the necessity of both parties getting independent legal advice at that time. So it's not simply a matter of being able to advise parties go off and get a financial agreement. To be binding, it in fact needs to be that both parties have independent legal advice about the effect of the agreement on the parties' respective rights and the advantages and the disadvantages of entering into the agreement. So again, really important in this area because, you know, financial and property settlements, some really basic cases, although it's not certainly one of our recommendations, but people can do it themselves. Spousal maintenance, I would say, is a really high risk area, really technical area, really does require specialist family law advice. So I do think we have a couple of minutes available for questions, but just before doing that, I am going to move on to the final slide. And that's just because it's got a little bit of information there about where we're located, how you can contact us, and also some information about our fees, which I know that a lot of people want to know, particularly if they are keen to refer a client and they want to know what the client's likely to be facing. The other important thing is we can also obviously have a joint conference. So as I mentioned, accountants often have a really good grasp on what the expenses and capacity questions are when there's a spousal maintenance case or situation between parties who have had a relationship breakdown. So I'm just checking the questions section just to see if there's any. Oh. No, it doesn't appear that there's any questions at this stage. There is an email address that's included on this final slide. As I mentioned, feel free to reach out with any questions that you have. I know it's often the case, I was just talking before this webinar, it's often, you know, a lot to actually kind of digest and understand, and it might be only upon reflection that you think of questions that might need to be answered. So certainly don't hesitate to reach out to us if you do have any questions. And again, even if it's to, you know, put us in touch with somebody who you think might need our advice as well. Okay, thanks for your attention this afternoon.